After exhaustive legal filings, 3 federal appellate judges delivered a final verdict on her conviction. Welcome to This Explainer. Today, we're opening up the active case file on what is arguably one of the most heavily scrutinized white-collar criminal cases of our time. We're going to objectively unpack the complex legal maneuvers, those incredibly strict procedural hurdles, and the stark penal realities currently facing Theranos founder Elizabeth Holmes. So, let's dive right into this definitive judgment. It really sets the stage for our entire analysis today. You see, the appellate court's recent moves have significantly narrowed the path forward for the defense. And examining exactly how and why they reached these conclusions, well, it gives us a fascinating look into the actual mechanics of the federal justice system. Here is how we'll break down this active docket. First, the final appellate verdict. 2, dissecting the legal arguments. 3, restitution and financial hardship. 4, inside federal prison camp Bryan. 5, investigations and misconduct allegations. And finally, number 6, the Supreme Court hurdle.
Section 1, the final appellate verdict.
Let's look specifically at the comprehensive ruling handed down in early 2025 by the Ninth Circuit Court of Appeals. A 3-judge panel, Circuit Judges Nguyen, Schroeder, and Nelson, issued their ruling. And the outcome was absolutely unequivocal. They unanimously affirmed the convictions and sentences for both Elizabeth Holmes and her former partner and Theranos president Ramesh Sunny Balwani. This ruling systematically dismantled the appellate challenges brought forward by the defense, effectively locking in the lower court's decisions. The court's precise, unfiltered language here is absolutely fascinating. Written by Circuit Judge Nguyen, the opinion officially declares the grandiose achievements touted to investors as a complete mirage. The court didn't mince words at all, legally categorizing the claims made by Holmes and Balwani as half-truths and outright lies. This strong judicial language really underscores the court's stance that this wasn't just some Silicon Valley startup failing to deliver. No, this was a calculated deception.
Section 2, dissecting the legal arguments.
To really understand how the defense team fought this and why they ultimately failed at this level, we have to forensically examine their primary appellate challenges. A huge pillar of Holmes's appeal rested on Federal Rule of Evidence 702. Basically, this rule dictates the strict parameters that separate lay witness testimony, which is just based on everyday personal observation, from expert witness testimony, which requires specialized knowledge, experience, or training. The defense argued that former Theranos lab director Dr. King Shuk Das improperly crossed this line when he testified that the Edison blood testing devices were unsuitable for clinical use. Because he was presented as a lay witness, the defense claims they were totally robbed of the rigorous pre-trial disclosures and cross-examination protections that come with an official expert witness. And this brilliantly illustrates the formidable hurdle of the harmless error test. The defense took the stance that Dr. Doss's unpermitted expert testimony heavily prejudiced the jury against Holmes. Now, the Ninth Circuit actually agreed with the defense on the premise. They conceded that, aspects of the testimony did indeed veer in the expert territory. However, they ruled that the error was ultimately harmless. In the legal world, a harmless error means the court acknowledges a mistake was made during trial, but determines that it just didn't significantly affect the final verdict, especially given the overwhelming weight of all the other evidence presented.
So the crucial point here is how the defense is pivoting to constitutional claims, specifically alleging what's called a NAPU violation. This occurs when the prosecution elicits or exploits false testimony without correcting it for the jury. The defense argues that during Holmes's trial, a recording showed her talking only about the potential for Theranos devices to be used on military medevac helicopters. Yet prosecutors allegedly allowed testimony suggesting the devices were actually being deployed to save soldiers' lives, and then exploited this narrative in closing arguments. This alleged discrepancy is exactly what's setting the stage for their future appeals.
Moving on to Section 3, restitution and financial hardship. Let's see how these affirmed fraud convictions actually translate into the staggering financial penalties enforcing accountability. Looking at the appellate docket, the Ninth Circuit fully upheld the joint liability for both executives. What does this mean? It means legally, they are both on the hook for the massive financial damages caused by the fraud. They simply cannot point fingers at one another to escape the financial restitution ordered by the lower court. And here is the exact sum ordered in restitution, over $452 million, to be paid out to 14 victims. Now, the defense tried to argue a completely different valuation methodology. They argued the restitution should only be based on the diminution or the drop in share value after the fraud came to light.
but the appellate court firmly rejected this idea, maintaining that the restitution must reflect the total investment amounts lost by victims. This included 10 specific individual investors, plus corporations like Walgreens and Safeway. Beyond the appeal, Holmes recently attempted to trim her 135-month sentence using a new federal sentencing guideline known as Amendment 821. This amendment allows sentence reductions for zero-point offenders, meaning folks with no prior criminal history. And, well, Holmes met that criteria. But to qualify, the defendant must also prove their actions did not cause substantial financial hardship. Judge Edward Davila flatly denied her motion, citing that her fraud caused massive financial harm to at least 12 specific investors, totaling hundreds of millions of dollars. The hardship was simply undeniable.
Section 4. Inside Federal Prison Camp Bryan.
Transitioning from high-level legal theory to operational reality, let's examine the facility where Holmes surrendered in May 2023 to serve her 11-plus-year sentence. Federal Prison Camp Bryan in Texas houses around 634 women, mostly convicted of white-collar or nonviolent crimes. It's a minimum security environment featuring dormitory-style housing without traditional cell doors, meaning the women can move relatively freely between buildings. It also offers First Step Back programming, like the Residential Drug Abuse Program, which can sometimes lead to sentence reductions alongside standard prison jobs. But while characterized as an open, white-collar camp, this environment presents its own unique and, frankly, severe challenges.
Section 5. Investigations and Misconduct Allegations.
We have to objectively note the stark contrast between the facility's pristine public administrative record and severe internal allegations recently uncovered by investigative journalism. The official administrative record shows FPC Bryan passed its 2023 Prison Rape Elimination Act audit with flying colors, boasting a strict zero-tolerance policy. However, investigative reports from the Marshall Project and NBC News paint a vastly different reality on the ground. Multiple whistleblowers and incarcerated women allege that staff members exploit their positions of authority, pressuring inmates into unwanted acts in deserted corners and blind spots that completely lack security cameras.
These allegations are serious enough that they've triggered action at the highest levels. This quote comes directly from a bipartisan congressional inquiry sent to the Attorney General, demanding answers about FPC Bryan. Lawmakers describe a regime of silence, fear, intimidation, and retaliation that actively prevents victims from coming forward. It highlights a dark truth. Even in a minimum security, seemingly open camp, the power dynamics inherent in incarceration can lead to severe abuses that completely contradict those official audits.
Section 6. The Supreme Court Hurdle. Returning to the legal docket, let's look at the incredibly narrow path forward for the defense as they attempt to overturn these convictions. In May 2025, Holmes's legal team asked the Ninth Circuit for an en banc rehearing, meaning they wanted all 11 judges on the court to review the 3-judge panel's decision. The court responded with a devastatingly brief 4-sentence order, unanimously denied. Because not a single judge on the full court even requested a vote to rehear the matter, her appellate options at the Ninth Circuit level are now completely 100% exhausted.
So the defense's final legal maneuver is a petition for a writ of certiorari to the United States Supreme Court, and the requirements for this are incredibly steep. They have to prove an important question of federal law is at stake, or demonstrate a circuit split, meaning different federal courts are applying the law inconsistently. Holmes's team is arguing exactly that. They claim the Ninth Circuit's handling of the false testimony and NAPU violations directly conflicts with precedent from the 2nd, 5th, 8th, and 11th Circuits. But despite this argument, legal experts note that statistically speaking, these petitions have a very low probability of actually being granted by the Supreme Court.
Which leaves us with this vital question regarding what we've covered today. What legal hurdles remain for federal wire fraud appeals? As this active case file meticulously demonstrates, proving a constitutional error or an evidentiary mistake at trial is literally only half the battle. Overcoming the harmless error doctrine, convincing a higher court that a mistake actually changed the jury's mind in the face of a mountain of other evidence, is the true final test. It is a nearly insurmountable wall for most white-collar defendants. And that wraps up our objective review of this complex legal docket. The intersection of evidentiary rules, constitutional claims, and the stark realities of the federal prison system makes this a truly fascinating case study in American jurisprudence. Subscribe for active case file updates to ensure you never miss an explainer on these evolving judicial dockets. Thanks so much for joining us for this explainer, and keep learning.